2025 Danville Boyle County Planning and Zoning Board of Adjustments meeting. Before we begin, I would like to announce the new hire for Planning and Zoning. Hannah Gray is now our Planning and Zoning Coordinator, and we welcome her to our meeting and to the city. First item on our agenda this evening is approval of the minutes from the May 20th, 2025 meeting. Motion from Jim to approve.
I second.
Second from Lonnie. Any discussion? All in favor? Any opposition? Motion carries. Tonight we have 4 public hearings, and I'd like to put item A down the list to the 4th item and hopefully move through these other ones a little quickly. If there's no opposition there, probably need a motion to make that happen.
So moved.
Motion by Pat, second by Mike. Any opposition or any questions on that? All in favor? All righty. Any opposition? All right, we already crossed that. Okay, so that will put Tony Patton first. Tony has applied for a conditional use permit for the operation of a one-chair salon at a residence, a 5¼ acre parcel known as 8620 Lebanon Road, Parksville, Kentucky. The property is zoned agriculture. And Hannah, will you be doing the information here from the staff?
As soon as I turn on the mic. So, this is what we have first on the agenda. So Tony Patton has applied for a conditional use permit for the operation of one chair salon at her residence, a 5.25 acre parcel at 8620 Lebanon Road, Parksville, Kentucky, and it is zoned agriculture. And you can see the lot right there on the right, and then the satellite view on the left. And then that's kind of a different viewpoint. And that's just kind of showing where it's landing in the ag zone right there. And then that's kind of the front of the house on the left side with Google Maps, and then the right side is the front of the house. Just to kind of give you an understanding of where it is and looks like. And then this is the description of the request and where it is for the zoning ordinance, or where it's referenced. And the home occupation is permitted only after first obtaining a conditional use permit, includes personal services such as hair salons, nail salons, etc. And then these are the findings required. The Board of Adjustments shall make the following findings prior to approval of any conditional use permit. The use is not detrimental to public health, safety, or welfare in the zone in which it is proposed. The use will not contribute toward an overburdening of municipal services. The use will not result in increased traffic congestion, additional parking problems, substantial increase in population density, environmental problems, or constitute a nuisance, and that the use otherwise meets the requirements of this ordinance. And there are no staff. There is nothing from us.
Is the applicant here? Would you like to speak? You don't have to. You can if you want to. Just opening a hair salon, one chair, and.
No employees, just me.
Okay. Any questions? Anybody?
Second.
Second. Jim? Preston? Second. Any discussion?
Due to this application being for a one-chair salon, that's a limit on the scope of it. Would the move it and the second agree that it meets the findings required under 3.8.5 that are up there on the screen? Okay, thank you.
Sound good to you, Jim? All right. Any discussion? All in favor?
Aye.
Any noes? Motion carries. Thank you. Second one tonight, Texas Roadhouse Holdings has applied for a variance to the pole sign and sign face. Ordinance allows for a 24-foot sign pole maximum height varied by 36 feet. Hannah, would you like to take this away?
Yes, sir. So Texas Roadhouse Holdings LLC has applied for the variance of a pole sign and sign face ordinance maximums as follows. So 25 feet sign pole maximum height varied by 36 feet, so total of 60 feet in height. And the 128 square foot max freestanding sign face varied by 208 square feet, total of 230.72 square feet on the 2.46 acre parcel known as 777 Freya Mave Lane in Danville. And the property is currently zoned as highway business. And so it sits behind Lowe's, and it's just outlined in purple right there. And on the right, you can see how it's zoned in highway business. And then this is kind of from the Lowe's and from the Cracker Barrel looking towards the lot on Google Maps right now. And that's just kind of what it looks like. And then this is the zoning ordinance reference. So these are just kind of where our ordinances fall and where this is trying to change. So these are what that is referring to, and that's our sign standards table, and it just gives our maximums, just to kind of show you where our ordinances are. These are the only staff item concerns. It just may alter the essential character of the general vicinity and may allow an unreasonable circumvention of the requirements of the zoning regulations, just because it's such a large change from the ordinance. But other than that, I think that is it on that item.
Hannah, I wonder whether you or Lisa could speak to whether there are comparable signs in that general area?
There are no other signs that have asked for this big of a variation, but it is reasonable because there are so many gas pipes that it's hard to see, and there's a hill in front of that highway. So if this would be the only time, I think that this variance would be, it's reasonable because there's no other place that it would be needed this large. So it would just be a different precedent. So it would just set a precedent for the future. And I think that's the only thing to take into consideration really. But I think because of the gas pipes around it, there is no other option to do it but that.
And the hill offsets some of the height on the pole?
Yes.
Okay.
So I wish I had a picture of it, but on the 2-lane road in the front, there's like a large hill that you cannot see over. So that is the reason for the big, large height variance. But I think it's just, reasonable to understand that this is the first of its kind, really,
Yeah.
to ask for that large of a variance.
It is quite a hill there.
Yeah.
Where's it gonna be? That's, my question is it to the front of the lot or the back of the lot?
Kind of where that purple is,
Up here?
right in the middle of that purple square.
The sign or the?
Oh, the sign itself. I honestly don't know. Yeah, I don't actually know where the sign would go. Yes, sir.
So you don't know whether it's here, or here, or here?
No, sir.
Is the applicant here?
The sign would be more, it's almost, yes,
Okay.
to the west side of the purple, but the sign would be almost in alignment with the front of Lowe's, so further back. So where you're pointing is where Chick-fil-A is.
Okay.
Well, to the left, and then almost all the way back where the bottom, yes, right now.
Okay.
Yes, yes, correct.
So in the back.
And that is over that hill?
In the back, behind the hill, behind the Chick-fil-A.
Okay.
Yeah, it's way back here. Any questions for Hannah?
And that was my question, where the position of this post is. A variance from 24 feet to 36 feet and from a 28 square feet to 230 square feet is a big difference and represents a significant difference from other signage along that area. If I understand, this is going to be in the rear of the lot, more distant from the bypass.
It is approximately, I think it's 620 feet from the bypass.
From the roadway.
And like I said, behind Chick-fil-A and also behind.
And those allay my concerns.
Would the applicant like to come up and say anything else? We kind of already hit you with some questions, but
Unless anybody has any questions.
anybody? Well then,
So I move approval that this does not significantly detract from areas, development in that area, given that it is related, it is located to the rear of the lot, significantly away from the roadway. So I move approval.
thank you, Preston.
I second.
Second by Lonnie. Any other discussion? All in favor? Looks like everybody's in. There you go. Next item, I'll just make this easy on myself. Rusty Lesky has applied for a conditional use permit for the operation of a short-term rental on .19 acres, 507 North Third Street, Zone RM2. Hannah?
All right, Rusky Leskiv has applied for a conditional use permit. Sorry, I left off that B in there. Has applied for a conditional use permit for the operation of a short-term rental on the .19 acre parcel known as 507 North Third Street, Danville. And this property is zoned two-family residential. And you can see the zoning on the right side and the satellite on the left. And that's the front lot of it. And per our ordinances, this is kind of a screenshot of other Airbnbs around it with 507 North Third Street marked, just to kind of get an understanding of the market in that area for Airbnbs, which are good. And,
Could you put that up again, please?
yes, sir, yes, sir.
Which one is this?
This is the 507 North Third Street.
These are just,
Let's get. Oh, it
The
is,
big dot.
I wish I had a laser. Yep, that is it.
Okay, I'm good now, ma'am.
And this is just showing you the other Airbnbs around it to kind of give you an understanding of the market in the area for Airbnbs and short-term rentals, which are plentiful.
is that a nightly rate? I'm in the wrong business.
And the zoning ordinance referenced is the 5.2.4 C3, and I'm sorry, I ran into a meeting and I did not get to finish that, but yeah, that is where our ordinances lie for short-term rentals. And it just talks about overnight accommodations, characteristics, accessory uses, and examples, including short-term rentals. And I don't believe we have any, and these are the findings required, but we do not have any staff concerns at this time.
Is the applicant present this evening? No applicant? Okay.
I have a rental property that joins that property. I'm at 508, it's my rental property.
So this is your property?
No, it joins, it's beside mine.
Okay. All right. Would you like to speak in support of the Airbnb? If you, please come to the microphone if you got any questions or comments.
Mr. Chair, I think we should maybe not hear public comment or especially public opposition without the applicant here. We've recently been through this with the Planning Commission. There's a way that you can designate someone to go in your stead, but if the applicant or their representative is not here, there's a prohibition on having the hearing. So the safest option might be to table this matter. I have
Okay.
questions about it anyhow, just
Yeah.
nothing grave, but I think we'd do better with Mr. Lescavere.
Excuse me, ma'am. I
Sorry to
think-
inconvenience you coming out tonight, but
So it sounds like we may table this for the next monthly meeting. Yep. And Willie would like to make that motion.
I move that we table this to the next meeting.
Thank you, Willie. Anybody?
I'll second that motion.
Second by Pat. Any questions on that? Comments? All in favor? All righty. Tabled for next month. That only leaves the one we've all been waiting for. The tabled administrative appeal from Emily Bear. And I am going to let Henry say a few words before we carry on, if you don't mind.
thank you, Mr. Chair. We are going to resume hearing on the matter of Ms. Bear's administrative appeal. Your vote last time to table or postpone allowed council to either redo their presentation or supplement. It was kind of left up in the air. And the board seemed to invite additional information, maybe in an effort to break the tie or further elucidate people's vote. We are going to proceed now, as we often do with administrative appeals, that is, the appellant goes first, and they carry the burden, and they're going to give their case first. After that, the official responds, and again, it won't be me representing the official, it'll be Ms. Thornberry and Mr. Hackley doing so. The attorneys have really worked this case. There has been discussion among all of us, vigorous debate, and I want to let you know that during the appellant's presentation, you will probably be presented with the opportunity to hear witnesses. And furthermore, if you do have witnesses presented to you, I'm going to say that there will likely be an objection to those witnesses. This is all in keeping with and normal for what we do here, which is a quasi-judicial proceeding. And so when there's an objection, should there be one, you'll hear brief arguments on that objection. I'll give you such counsel as you require, and then after that, you'll be able to make a vote on whether to sustain the objection or not. So we'll have appellant, we'll have objection response. If there's anyone from the public here that's not aligned with one of those sides, I think they would have the opportunity to talk. After that, the appellant gets to offer rebuttal, and then at that point, you deliberate and vote to adopt a set of findings. And I think that's all I have at this time. Any questions for me, or should we turn it over to counsel for the appellant?
Mr. Eaton,
Thank you.
Thank you.
floor is yours.
May we
Henry.
have a motion to take it off the table?
What's that?
Do we need a motion to take it off the table?
I guess, yeah, we do need to vote to take this off the table. Jim moves.
I'll second.
Second by Lonnie. All in favor? Any opposition? All right. Mr. Reed.
Henry, can you unmute the Zoom there?
To take it off the table, I got you.
Using that camera up there, so I'm going to turn this around. And you might have to speak up, make sure your microphones are on so that they register. And there we go.
Yeah, please make sure that if you make any comments from up here, your mic is on.
Well, gentlemen, it's good to see you again. And Mr. Miles, nice to meet you. My name is Eric Eaton. I represent the appellant in this matter, Emily Bear. She brings this appeal to challenge a notice of violation issued by Junction City and a stop work order related to that issued by the county. Both of those things relate to the construction of a home that is properly zoned under the joint ordinances and was expressly permitted by the county before the construction of the home began. Now, I know we were here last month, and so I don't want to repeat myself and risk boring you with a repeated spiel, but I do want to hit some highlights for purposes of making the record. And so the way I thought I'd do that was present you a summary of the facts that I presented last hearing. What I've got is a packet for each of you like last time. There's 2 pieces of this. You can take it, pass it down. The first piece of this packet is going to be the notice of violation and the applicable ordinances. Mostly those are definitions. And then the second piece of the packet are going to be exhibits, most of which you've seen already, and I'll reference those by number. I should have one to make it all the way down here and a copy for you as well. While those are getting passed out, I'll catch us up to where we're at. This home is located in R1A under the joint ordinances. R1A permits modular homes, and they do not allow mobile homes or manufactured homes. I know that mobile home is kind of an outdated term, but those are the definitions, those are the terms used under the joint ordinances. So you got modular on one hand, and you got manufactured and mobile homes on the other hand. The key distinction about manufactured and mobile homes is that in order to be that, either of those under the joint ordinances, it has to have what's called a HUD label. That's true for manufactured and mobile homes. It has to have a HUD label. For modular homes, it does not have a HUD label. It'll have something else called an M seal, okay? That's the lay of the land in terms of what the zone is and what the joint ordinances prescribe relative to that zone. Now, this notice of citation, notice of violation comes to us from Junction City. And what Junction City has alleged, and you'll see on the first page of the ordinance and the notice of violation, is a violation of section 152 of the Junction City ordinances, not the joint ordinances, of the Junction City specific ordinances. And what that section prohibits is mobile homes. It says no mobile homes. So while there's 2 different ordinances, they're actually on the same page, in that in this zone, R1A, no mobile homes are allowed, and modular homes are allowed in this zone. So that's what I'm going to be talking about, is this house is not a mobile home, and this house is a modular home. So that kind of catches us up to where we're at. What we talked about last time, and this is kind of a key piece of this, is what Exhibit 1 will show you is my client applied for a permit from the county to build this house before any of this happened. She supplied the county with all accurate information about the home, contact information from where the manufacturer can be contacted to discuss details about the home, gave the whole information to the county. That was after the city told her, get in contact with the county, with Rusty, to make sure you're compliant and make sure you're a modular home. County, Rusty, told her to fill out this application. She did. You'll see on Exhibit 1, Planning and Zoning approved it. That's up at the top, Planning and Zoning approved. Exhibit 2, she received the permit from the county. Now, Rusty explained the permit language and the application language is a little inartful last time because it interchangeably uses manufacturer, mobile home, modular home, but he explained he has one application and one permit for all this type of home. The bottom line is she asked permission to build this thing. She gave all the information to the county about this thing. She got permission to build this thing. That's Exhibit 2. She purchased a modular home from Uri's Home Centers. Uri's sells modular homes, but they also sell manufactured mobile HUD-regulated homes. I talked about that HUD label earlier and the M seal. They sell both. Both are for sale. She went to the store online and said, I'd like a modular home. We know this because in Exhibit 3, which you have in front of you, you've got the sales papers. And it describes this thing as a, quote, residential modular home. It identifies all the components of the home And every one of those components is identified as being built to the modular standard. Those components, all of which are substantially assembled at a plant called Sunshine Manufacturing. In order to construct this thing, you can't just buy the home. You got to get it approved by the relevant authority. In the circumstance of a modular home, not a manufactured mobile HUD-regulated home, but in the circumstance of a modular home, you submit construction plans to the Housing Building Code, Division of Housing Building Code. That's a division within the Public Protection Cabinet. And they review those to determine if the plans are compliant with what's called the Kentucky Building Code. The Kentucky Building Code regulates two things: stick-built houses, which is just a regular house, single-family house, and it regulates modular homes. It does not regulate manufactured mobile HUD-regulated homes. Those are built under a different standard, hence the HUD label. So she sent these construction plans to HBC, Housing Building Codes, and they issued her a letter. That's in Exhibit 5 here for you. And it says, congratulations, your home is consistent with the Kentucky Building Code. What that means is it is built to the same exact standards as a standalone single-family dwelling. And it is built to different standards than a HUD-regulated manufactured mobile home that would have a HUD label. So they said, congratulations, you're consistent with the Kentucky Building Code. Uriz transported the home to the real property for final assembly. Obviously, to transport the home from the plant to the real property site for final assembly, it required trailers and a truck and a wheel and a chassis and a hitch and all those types of things. But then it was assembled to the permanent foundation, and those items used to transport it were removed from the real property because they are not part of the purchase of this real property. You know that because in the sales documents in Exhibit 3, it lists what is involved in the purchase of the property. Absent from those things are the hitch, the trailer, the wheels, all those things. It's not part of this product. So substantially assembled and transported to the site for final assembly on a foundation that is approved by the Housing Building Code, because part of the Kentucky Building Code includes requirements for foundations, just like any regular site-built house that any architect would design and somebody would come out and build has requirements for roof, walls, ceilings. It has requirements for a permanent foundation. And it meets those things because the Kentucky Building Code from the Housing Building Code says it meets the Kentucky Building Code. Importantly, I want to double down on this. No HUD seal has been issued to this house or will ever be issued to this house. This house is not a HUD-regulated home. And I keep harping on that because if you look at your first page or your first part of your packet where it's got the definitions of the different things, manufactured, mobile home, it requires to be those things, a manufactured or a mobile home, a HUD label. You will never, ever on this earth see a HUD label affixed to that home. It also doesn't have a VIN. You might think of a mobile home has a VIN and has title and it's registered with the county clerk's office. None of that exists for this home because it is not a HUD-regulated mobile manufactured home. So about this time, the neighbor complains, everything becomes the way it is. The county, through Rusty Cox, investigates this issue and says, well, I issued the permit. Should I have issued the permit? In Exhibit 8, you've got a document he prepared. And on March 17th, 2025, he conferred with Lisa Bowman of Planning and Zoning, and it was found, this is his words, not mine, that modular homes are allowed in the zoning district and no mistake had been made based on the information we were given. So there was some argument last time about cases about errantly issued permits and those types of things. Not applicable here. Rusty investigated that and doubled down and said no error in issuing the permit. So that's a summary of where we're at from last time. But I've got some additional information I'd like to share with you today, in addition with this information, to help explain that this house is, as a matter of fact and law, a modular house, and is not, as a matter of fact and law, a mobile home or a manufactured home. The first thing of this is when Housing Building Code granted the approval, saying you are consistent with the Kentucky Building Code, it has to review construction plans that are submitted to it. Those are attached for your reference as Exhibit 4. And they are detailed and specific and technical and have to do with load requirements that the floor, roof, ground can require, all these things that all relate to the structural integrity of the home as it relates to the foundation going up. There are specific notes in here about the foundation, and it's identified within these documents that an engineer designed and approved the permanent foundation for this home. That is significant because that does not happen for a HUD-regulated manufactured mobile home. It does happen and is required for a modular home. The reason we have these documents today to beat a dead horse is because this home is a modular home. That's why Exhibit 4 exists. If it was a manufactured or HUD-regulated home, these things would not exist, and they would not be reviewed by the Housing Building Code. So let me take you back to this definition of modular. It's a dwelling unit constructed on-site in accordance with the state municipal code. We know that it was. It's a dwelling unit. Nobody argues that. It's constructed on-site in accordance with state municipal code. HBC, bless this thing. You've got the construction plans in your hand to show how this thing was built and what HBC blessed to have it be built with the state municipal code. There was argument last time about the extent to which it was constructed on the site. That term's not defined under the joint ordinances. What I can tell you is the house was not there, and now the house is there. And the word you use to describe that when you're talking about buildings is construction. It didn't grow from the ground. It didn't fall from the sky. It was built. It was removed from the transportation system and assembled and affixed to the permanent foundation that was dug and prepared for this thing and hooked up to the facilities. That's called constructed. It was constructed on-site in accordance with the state municipal code. It is composed with components substantially assembled in a manufacturing plant. We know that because you're looking at them in Exhibit 3. Those are the components that were substantially assembled in the manufacturing plant. Now, back to this construction issue. Part of the definition of a modular home is dwelling unit constructed on site, composed of components substantially assembled in a manufacturing plant. Well, if something is substantially assembled in a plant, the amount of construction necessary on site is going to be relatively minor compared to the substantial assembly that already occurred. So the fact that it arrived mostly built is not a violation of the ordinance. It actually is part of the definition of what a modular home is under the joint ordinances. One thing I wanted to tell you, I keep harping on this HUD label versus the M seal. Exhibit 6, you've got it. That's the M seal that's issued by HBC. Would you take a guess as to what M stands for on the M seal? Modular. The reason it has an M seal is because it's a modular home. A manufactured mobile home does not have an M seal. And a modular home does not have a HUD label. They're opposites in that way. So this is a picture from our house at issue. It's got the M seal. As the general counsel for Housing Building Code told me on the phone last week, what else is there to talk about? It's got the M seal. That's really the end of it. But there's more. It's transported to the site for final assembly on the permanent foundation. The fact that it was transported to the site is not a reason that it violates the joint ordinances. Kind of like substantially assembled, it's part of the definition. It can't get from the manufacturing plant to the site without being transported. So the fact that wheels and a trailer were involved in getting it from the manufacturing plant to the site doesn't make it out of compliant. It makes it, by definition, a modular home under the joint ordinances. It was finally assembled to the permanent foundation. Again, on this construction issue, if final assembly is required, that means not very much construction is required. It was finally assembled to the permanent foundation. Now, there was a big hullabaloo about, was it a permanent foundation? The answer is a matter of fact and law and not one of opinion. The answer is yes. The reason we know that is the definition of permanent foundation under the joint ordinances, under you guys' joint ordinances, is a permanent masonry, concrete, or other footing approved by the building official. 2 building officials approved this permanent foundation. First one is the Housing Building Code, by saying that it's compliant with the Kentucky Building Code, which has requirements about permanent foundations. So they've already said this is consistent with what a permanent foundation is required for any other stick-built house and/or a modular home. We approve this, and you are allowed to build the home and get the M seal. So it's already approved by the Housing Building Code, and it's concrete. You've got details in there. There's concrete blocks, concrete piers, concrete perimeter wall. It's compliant. I know that to a layperson, it may not look like it meets the definitions, but I'd like to remind you of 2 facts. One, it's half built as it stands because somebody issued a stop work order on it, and we complied with it. So it's not completed yet, number 1. Number 2, the plans, and it's being built consistent with the plans, were approved by the people in charge of deciding whether or not it's a sufficient permanent foundation. But it was also approved by another building official, Rusty Cox, when he issued the permit to allow her to build this to begin with. So it's issued an M seal. It was not issued a HUD label. Now, I've referenced HUD label a lot. Let's look at Exhibit 7. Let's look at Exhibit 7, if you would. That's a picture of a HUD label. Okay, does everybody see that? That's what I'm referencing when I say a HUD label. That picture was not taken from my client's house. Do you know which house that was taken from? The house next door. 91 Simpson Lane has a HUD label, a manufactured mobile home under your regulations, bona fide manufactured mobile home. Not one where we can argue whether or not it was constructed enough, not one where we can argue whether or not the permanent foundation was enough. We're talking about one regulated by the state and federal authorities that says that house next door is a manufactured mobile home regulated by HUD. We know, because Exhibit 6, ours is not that. Ours is a modular home because it's got the M seal. Now, I don't know, and I don't care whether or not the lady at 91 Simpson Lane had any enforcement authority against her, or whether or not the neighbor complained against her, or whether or not she had an application and a permit approved by planning and zoning. But I know that my client did. My client got permission to build the home that turns out is more compliant than the home next door to begin with. While we are comparing and contrasting my client's home and the one next door, Exhibit 9 and 10 is the relative PVA cards for those homes. My client's PVA card was issued yesterday. So this is fresh, hot off the presses. And there's a couple things I want you to see. There's a designation for foundation described by the PVA's office, and that's what they use to describe to generate their tax assessed value. For my client's home, where it says foundation, it says concrete block. Okay? We've talked about how that's compliant with Kentucky Building Code, and we can have argument about that, but that's what it says. It says concrete block. If you look at Exhibit 10, the one with the HUD label, the manufactured home, foundation, MH, non-permanent. So the PVA, Housing Building Codes, Boyle County, URES, my client, we're all on the same page. The house at 111 Simpson Lane is a modular home built consistent with the Kentucky Building Codes, and the one next door is not. The only people that have a different opinion about that is Junction City and the complaining neighbor, neither of whom are able to demonstrate to you that my client has a HUD label affixed to her house, which is required under your ordinances to be a manufactured or a mobile home. Now, the reason I keep arguing about it's not a mobile home is because if this notice of violation says violations of City of Junction, City Code of Ordinance exist, briefly stated, the property is in violation of Section 152. If you look to the next page, Section 152 is about mobile homes. So the allegation that I'm appealing, the one that they are trying to prove, the one that you guys need to decide whether or not substantial evidence supports, is whether or not my client's home is a mobile home in violation of Section 152. As I've shown you through all these exhibits, frankly, all the exhibits I showed you last month and the ones I'm showing you now, it's not a mobile home. And as a matter of law and a matter of fact, and not as a matter of opinion, it is a modular home. And those are distinct things at the local level and at the state level and at the federal level. Before I get off the PVA value, I want you to look at Exhibit 9. One of the things you guys' job is to do is to apply the ordinance as written. But the reason these ordinances exist and the reason we do have conditional use permits and those types of things is because as an overarching theme, an overarching goal, what we are trying to do is protect property values. Take a look at the 2026 freshly appraised PVA taxable value of my client's property compared to what it was a year ago before she started construction of this home. As of yesterday, it was taxed as over $150,000. Before she started construction of the home, it was about $30,000. So by constructing this home, which is half finished, by the way, she has 5x'd her taxable property value. Isn't that a good thing for the city, for the county, for the neighborhood? Isn't that something that we should strive to do? It's more taxes? Isn't that better? That's what she's done. She's improved the property. And so I say all that to make another point, and it's one of my last exhibits. In Exhibit 11, what you'll see is about 5 or 6 notes to you from her neighbors up and down Simpson Lane that give statements to the effect of, we support this home. I mean, this is one of them. I personally observed the home and can affirm that it is well-built, well-maintained, and visually consistent with the surrounding properties. In my view, this home enhances the overall appearance of our neighborhood and contributes positively to the community's character and value. I have no objection to the presence of this home in our area, and I stand by my neighbor and support their right to peaceful enjoyment of their property and fair treatment under the law. There's about 6 of those in here. The reason they support that home is well-grounded. It's raising their property values. It's making the neighborhood better. And, as I've mentioned, it's consistent with what the zoning allows. And it's consistent with what their county officials have already approved. What are we doing here? The neighborhood supports it. She's got permission for it. She didn't need permission to begin with because it's compliant. Something else I'd like to let you know, and some of our witnesses can explain this more. The community's support for construction of this home is not just a localized support. It's actually reflected in our General Assembly and enacted by our governor in April. House Bill 160 just came down, and it'll be effective next summer. That's going to invalidate, unlawful, illegal, any ordinance that prohibits manufactured homes where single-family homes are allowed. And they are giving and the relevant authorities are giving instruction to municipalities like yours to say, heads up, these types of ordinances need to be rewritten because they're going to be illegal effective July 1, 2026. So I say that to say, not that my client's home is a manufactured home, but this whole argument of they can't build it here is going to go away. That's good news for the next door neighbor who has a home with a HUD label that's out of compliance. But it just shows where the community support is on this. I have made technical arguments, and I've shown you exhibits, and I've quoted you cases and laws and all this kind of thing. But I really don't want you to get lost in the great injustice of this all. My client has been trying to live in this home for 6+ months, and she's done everything right. Nobody, not any of the attorneys in here, not any of the enforcement officers, nobody has alleged she's done anything wrong. Nobody has said she's misstated anything on an application. Nobody has said she's lied about anything. Nobody has said she's done a bait and switch. She moved here from out of town, went to the mayor's office and said, what do I do? He said, call Rusty. She called Rusty. Rusty said, fill out this form. She filled out this form. She got permission. She went to Rees and said, I've got permission. I'd like one modular home, please. She got a modular home, and then this happens. That's wrong. And then this issue of, oh, well, the permit shouldn't have been issued to begin with. I've already explained to you, that's just a lie. That's not true. Rusty's doubled down on this and written a note to you that you have in your hands that says the permit was issued without error. Ultimately, I'm supposed to argue that substantial evidence doesn't support this notice of violation. And I've got 3 points I'd like to make on that. This notice of violation, if you're looking at it, I'm not making things up. I'm looking right at it. It alleges it's a violation of Section 152 because the home was transported fully assembled to the site on wheels in a tongue. As I explained to you, that's all true. But that's also expressly contemplated under the definition of modular home. Definition of modular home specifically to be a modular home, it must be transported to the site for final assembly. To be a modular home, it has to be substantially assembled in a plant and then transported to the home for final assembly. So these allegations are not proof that she's done anything wrong or that her home is out of compliance. It's consistent with the definition of what her home is. Second, I think I've explained this thoroughly. The difference between modular and manufactured home actually has nothing to do with that. It has to do with how it's built and who's regulating it. In this case, a modular home is built consistent with the Kentucky building codes, and it's regulated as being in accordance with that code with the Division of Housing Building Codes. A manufactured, mobile, HUD-regulated home is not. There's a different division, different set of folks at the state and federal government that regulate this. This home is a modular home, not a HUD home. It does not have a HUD label. Third, the only evidence you've got to not sustain this appeal is the opinion that it's a mobile home. We think it's a mobile home. There's not evidence, anything about these technical documents, anything she's asked for, anything she's received, anything she's bought, anything she's financed. None of that is going to come in to show this is a mobile home and this is not a modular home. All that you're left with is someone's opinion. And so you look at the evidence that I put forth to you last month and today, and there is no question that substantial evidence does not support this notice of violation. And I think on the fact alone that she sought approval, received approval, the house next door is out of compliance as a matter of fact and law, all goes to the great inequity of this thing, that allowing her home to be fined or whatever the enforcement remedies are, rejecting my appeal is arbitrary and capricious. Now that's my spiel. I do have two witnesses, one of whom the board, not me, the board has subpoenaed at the request of Rusty Cox. He is Kerry Graham. He's the field operations manager for the Housing Building Code, Division of Housing Building Code. I think he can give you some insightful testimony and answer some questions about the difference between modular, manufactured, what that means, and his experience in dealing with these, if you have questions for him. The other one I have is Richie Altman. He's available on Zoom. He is involved in Uri's Home Center. I believe he's the CEO, if I'm not mistaken. He's the CEO of Uri's Home Center, and he can, I assure you, very thoroughly explain the difference between modular, manufactured home, what they have for sale, how this thing came to be purchased, what they delivered, and those types of questions. I'm happy to ask them questions. I have some prepared. I think I've kind of addressed what they're going to say anyway. They can come up and confirm that what I've said is accurate or make any corrections or answer your questions. I'll leave that to you guys. I want them to be helpful. I want them to be an assistance to you. So I'll leave it at that. I think council had some objection or something. I wanted to say that. Or not, I'll call Carrie now. Carrie, can you come on up? Carrie, would you introduce yourself to the board, please?
Absolutely. My name is Kerry Graham. I'm a field operations manager with the Department of Housing, Buildings, and Construction with Building Code Enforcement.
Can you tell them what housing building code is and what you do there as field manager, field operations manager?
Well, we help enforce the Kentucky Building Code and Kentucky Residential Code, basically consisting of design parameters for code that include structural design, fire safety, mechanical, electrical, plumbing, all those trades that are part of a building construction. So as far as our role goes in this particular process, this unit was submitted to our department to be reviewed and approved as a modular building, which is a modular home, which is an industrialized building system. It was reviewed as such and issued an approval as such. So that particular unit is not a manufactured home. It is, what I can say about the foundation system is it is very consistent with all the other modular structures that we approve, inspect. Statutorily, we cannot inspect a site placement of a single-family dwelling. We can do anything two-family and up. Now, generally what happens is if there is a building official like Rusty Cox that has single-family dwelling enforcement, we would review the model itself because by law, we review all models. And then he would then inspect, issue the permit, review the site placement, check out the foundation system, which is very consistent with a commercial unit that we would inspect that would be our jurisdiction. We do all first-time site placement of commercial modular buildings, and I would say probably 90% of those have a foundation system, which we do, in fact, consider a permanent foundation system. They are generally engineered. So the Kentucky Building Code and Residential Code has prescriptive paths to build a foundation system, to stick frame a house, and then if it would go outside of the prescriptive requirements, generally speaking, we then request a plan to have a seal and signature of a Kentucky licensed design professional, such as an architect or an engineer. So we do ours in two, the ones that we have jurisdiction, we do ours in two separate permits. We do the model, and then we do the site placement. Now, generally speaking, a footing and foundation system that is similar to what has been designed for this, we would request an engineered plan. And essentially, it's engineered to meet all the required design loads that are out of the Kentucky Building Code or Residential Code, you know, including dead loads, live loads, seismic, wind, snow, all the,
Stuff listed on the first page of the
yes,
site.
all the different things that are required to meet the Kentucky Building or Residential Code.
And let me ask you this, because this home has a stop work order on it, I don't think the final blessing of the foundation has happened yet, because it's just been delivered to the home.
I'm not sure where Rusty Cox is at in his permitting
Well, he's done a
process.
stop work order and stuff.
Yeah,
Yeah.
so.
So is the plans as it relates to the foundation consistent with those that are engineered, designed, and approved that you have seen?
It is very similar, yes.
And there may be final steps of approval from HPC and Rusty and others once it does get finally assembled to the foundation.
Our portion of the modulars is complete on the
Okay, so
state
we left
end.
that.
It's, yes.
Okay. Now,
And then the site placement would be done by Rusty, which would include, generally what we look at is the anchoring, the footing foundation, the anchoring of the unit, and then site-built elements such as stairs and decks and other items as such.
all right.
I got a question. And you said that part is complete?
Which part?
The part that you are in charge of, make sure that it is complete, the
Yes,
foundation?
no, sir. We're not in charge of the foundation. We're just.
No, the connecting, to make sure it's,
Fixing it to the
yeah.
permanent foundation.
We do not do that part. We look at the modular unit itself. That would be Rusty's responsibility as the local building official to do all the permitting, inspection of the actual connection points and the foundation and the footing system.
But you
But
approve
I-
the plans that
We,
predate that process.
so as far as the footing and foundation, no, we do not, because it could differ from site to site. So there's not always a one-size-fits-all. So that's why that should be up to Rusty to verify the footing and foundation system.
But my question is, whatever that you're in charge of, making sure it's done, you're finished?
Yes,
You've
our
approved it?
portion is finished. But what I have tried to explain is that we have accepted the similar type of foundation, footing and foundation system for commercial buildings. Sometimes it depends on the size of the modular building. It could come in one unit because it can be transported as such. And if it's a larger building, it may come in modules. And generally, there is some construction. And to me, that's really the point of the definition of construction is, you know, you're looking at, you know, first of all, you're looking at the link of the modular unit to the footing and foundation system, and then any other construction such as connection of utilities. And then also, when you have more units to assemble a larger building, you can't always transport from the manufacturing facility to the site. You have to break them down in modules, and sometimes there's some construction required, you know, to connect and link those modules. And a lot of times, they'll just wheel them in, they'll leave them on the wheels and everything, and they'll build up the block piers, and generally they'll pour a foundation, a footing system, and then they'll stack the blocks. And they'll have an anchoring system like a strap or something like that too, to help keep the wind resistance.
If someone submitted plans that would be more consistent with a manufactured mobile HUD-regulated home, or otherwise failed to meet the standards of the Kentucky Building Code, what would HPC do in that circumstance?
So we have a separate section that would include manufactured housing. They would issue any kind of reviews, or they would do any kind of reviews and whatnot of that particular type of structure, and they would issue the approvals and do the site inspections of a HUD-designed, manufactured or slash mobile home.
In other words, you would ship it off to the other
It would be
department,
another section of our department.
not yours,
Yeah, absolutely.
because you deal with modular and stick-built
We,
modular
yes.
homes.
So generally, I mean, a stick-built home is built out of the same code as this home was. I mean, you could build the same house out of our building code as this. I mean, it could look exactly the same. I mean, I don't know what you're looking for here, but I mean, it's designed out of the Kentucky Residential Code. They could build it on site and it will look exactly the same as it is if they wanted, if it was designed in accordance with the Kentucky Residential Code. So I mean, he's really hit the nail on the head on pretty much everything he said as far as state codes and regulations go and compliance with the state codes and regulations.
Mr. Graham, just a quick question over here. Did I understand you correctly that sometimes modular homes, in fact, arrive in one module? It's not necessarily going to be two
I
separate
mean,
pieces coming to the site?
It just depends on the needs of, the facility, so.
Right, but you have
sometimes-
seen that before?
Yes, sometimes they are just one module. Yeah.
Any other questions for Mr. Graham?
Thanks, sir.
You're welcome.
Yes, I think that is appropriate to.
Okay.
He's right there. Do you have,
Could you take the microphone again, sir?
he'd like to ask you questions.
And Mr. Hackley, if I could ask you to join him up there, so it's captured.
You said that a stick-built home could be built just like this home that is placed on that lot.
Yes, actually.
Okay.
They could.
Would a stick-built home have a steel chassis and a tongue?
Well, no, sir, not a stick-built, but a modular home would, because they have to transport it somehow from the factory to the site. But as far as the way it appears, you could design it to look exactly the same and build it from a stick-built home.
Now, to your knowledge, nothing that you've testified to today and none of the regulations you're testifying to negate Boyle County law, do they?
I would say you could borderline on the mini-maxi provisions of a mandatory state building code, which means that you cannot enforce ordinances that are less than the Kentucky Building or Residential Code.
More
or
restrictive.
more, no, it's less, it's a mini-maxi. So you cannot enforce an ordinance that would be less than or more restrictive than the Kentucky Building Code or Kentucky statutes.
Are you familiar with Boyle County law regarding, have you read the ordinances that we're dealing with here?
No, sir.
I believe that's all I have.
Okay.
Thanks, sir.
I have one question, please, if I may. Melanie Thornberry, I represent Luther Galloway and some other neighbors. Can you tell me again, please, sir, which department it is that you were with?
Sorry to interrupt, we cannot actually hear you all up there,
Oh,
so
I'm
can you?
sorry.
Okay.
Thank you, Anna.
A microphone, okay.
I'm with the Department of Housing, Buildings, and Construction,
So building codes
and
enforcement?
I'm with the Division of Building Code Enforcement.
Okay. And so in the packet of documents that were given to the board by Mr. Eaton, there was a document number 5 that previously, sorry, I can't hold microphones, and do what I'm trying to do here. So, excuse me, this document number 5,
Yes.
which in the last hearing was submitted as the appellant's or applicant's document number 4, which is the only copy that I had to look at. Is this letter from someone in your office?
Yes, that's from a plan reviewer and then signed by the technical advisor or supervisor. That is a letter for an industrialized building system. We just put the K, Kentucky Industrialized Building System Model. So basically, if you look at the definition of a modular building, it says it's an industrialized building system.
Okay. So what I would like for you to do, please, because I want to.
The plans are associated with the
Right.
letter.
Yes, because it references those plans in here. But what I would like you to do for the members here of the board, if you would please, in the 4th paragraph down, what does it, can you read the last, I believe it's 2 sentences of that paragraph beginning here, please?
It
With
says,
all,
KIBS site placements shall be approved through building code enforcement. It will be necessary to contact any other authority having jurisdiction and to contact the local planning and zoning department to review any requirements and permitting that they may require.
so would you take this statement by your department to be indicative that, sorry, messed up my train of thought, be indicative that your department does not supplant or supersede local planning and zoning requirements and ordinances?
As long as they do not supersede state law. Mini-maxi code, statewide, state supersedes local.
Under what chapter of KRS? Or
I
what
would-
chapter of KRS are you operating under?
I would just say that I have been involved in several building official complaints on local levels, and they try to enact ordinances that are in that conflict with Kentucky Building Code
Which is a
statutes.
separate chapter
Which is a
within the
statute.
Kentucky Revised Statutes, correct?
Yes, Kentucky there are KRS, specific KRSs, and as far as I know, all of the definitions of modular manufactured homes, all those are KRS. I've got them actually with me.
My point is, are you aware that the Kentucky statutes have a chapter separate from that which addresses building code that authorizes and delegates to the local governing bodies land use management and enforcement of
I
their
would agree.
adopted land use
Yes, I do
management?
recognize that.
Okay,
But they cannot enact anything that would be in confliction.
they
with-
actually can, and I have the statute written down, but it does specifically say in KRS Chapter 100
Mhm.
that the most restrictive will apply. And KRS 100 is that which gives the authority to the local government bodies to enact their own zoning ordinances, which
Right.
is separate than the statutes under which your department exists and your department operates. Am I correct? Yes or no?
I cannot speak.
I just need yes or no on that.
I cannot answer you
Okay.
that. I would need our general counsel's representation to, because I would need specific examples of which specific ordinance you're referencing. And then I would have to review our specific KRSs to make sure they're not in conflict.
In other words, you feel that I'm asking you to draw a legal conclusion.
You're asking me to answer a question that I don't know what your question
But
is.
the letter from your department did
So
state that it
essentially,
needs
what
to
that
look
is-
at,
Is like for planning and zoning.
Uh-huh.
If you have a specific ordinance that doesn't come in, that's not conflicting with they can't just go and say, I mean, let me try to think, like a modular home.
I think you've
So-
answered it
so
in
like
that you
the
have read.
ordinance that you have that says a modular home can be placed on this lot. And if you go, our
be
definition
our
of a
local
modular
planning
home,
and
if you were to change the definition of a modular home in your ordinance, then that would be in conflict, that would not be, that would conflict with the mini maxi provisions of the state law. So if you changed our definition, like if you said a modular home is other than what it, a modular home is something that is brought in on a trailer axle or something like that. I mean, that's kind of the gist I'm getting here, is that it was brought in on a chassis.
Well, I don't,
So
no,
then
I,
it's a mobile home, you
I
know?
didn't-
But that's
I
not,
didn't ask for your conclusion about
Yeah.
that. I wanted to make sure that you were aware that the letter from your office does specifically point to
yes, I understand there are
authority having
specific,
jurisdiction, local planning and zoning departments, and their ability to review requirements.
yes, I mean, there would be specific zoning. I mean, I know there's areas that you could provide.
Yeah, you've done it.
know.
Thank you.
Yep.
Just one follow-up on that, just to kind of cut to the chase here. On the definition of manufactured home under the Boyle County ordinances, I don't know if you've reviewed those or not, the board has them. I'm reading from them right here. First one has a HUD label. Does this home have a HUD label?
No.
Okay, I'm looking at mobile home, you guys got the definitions right here, mobile home, structure for residential use, which has a HUD label. Does this home have a HUD label?
No.
Okay, no further questions, thank you. I've
Thanks,
got
sir.
Richard Altman next, just for a couple of brief questions to make him available to answer questions about how this home was marketed and purchased. If that's right?
Go ahead.
You might confirm he can hear you before. Yeah, Richie, can you hear me? Can you guys hear Richie okay? We're getting a microphone so we can hear you better.
Hey, Henry, behind you.
Hello, good evening, everyone.
All right. I think that'll be a little bit better. Thank you. Richie, will you just introduce yourself and say what you do and who you are?
My name is Richie Altman. I am the CEO of Uri's Home Center, also co-founder. And also, guys, the other gentleman you see, probably to my right or my left, I'm not sure how your screen is Cole Wheeler, which is our attorney.
Okay. Richie, through your business and your REIS, do you sell modular homes, manufactured homes, HUD-related home, regulated homes? Do you sell both of those, all of those, any of those?
Yes, sir, we do.
Okay.
We sell modular, manufactured, and also what they call APU. Yes, sir.
Okay, so you sell a modular home and you sell a manufactured HUD home too, correct?
That is correct.
Okay. Did Emily Bear, my client, purchase a home from your REIS in recent memory?
Yes, sir, sure did.
Was it a modular home or was it a manufactured HUD home?
It was a modular home. Matter of fact, she had a special order because we don't keep those in inventory, or a limited number of those in inventory.
So it was a custom-built modular home?
Yes, sir, sure was.
On the custom-built modular homes, is there an engineer that designs or approves the plans for the foundations for those homes?
Well, we have a relationship with our manufacturer partners that have to be approved with Kentucky Department of Housing, which is actually a Kentucky mod approved builder. And they actually have the engineers that go through and submit all the engineer requests, et cetera, to make sure it's compliant with the state of Kentucky.
Okay, so an engineer had eyes on the plans for this thing before or
That is
once it was
correct.
purchased? Okay.
And they're stamped on every one of the documents.
Okay. Since it is a custom-built modular home, is this something that she can sell back to you or trade in or get an upgrade in any way?
Absolutely not. Modular homes are single destination origins to a piece of real estate, then are retired to that piece of real estate indefinite. To my knowledge, I've been in the business 15 years. I have never seen a secondary market for modular homes, and I deal with hundreds of banks nationally. I know no bank that will actually deal in a used modular loan process either,
So,
other than it being sold as real property once it's affixed to the real estate.
okay. I don't have any more questions for Mr. Altman. Does any of the board have questions to Mr. Altman? Okay,
Thanks, sir.
thank you.
Opposing counsel now has the floor. Looks like Mr. Eaton has,
We'll call Scott Terry. Tell us your name, Scott.
Scott Terry,
How are you employed?
Code Enforcement Officer for Junction City.
And as Code Enforcement Officer of Junction City, are there numerous codes that you enforce for the city?
Yes,
What do they include?
all the ordinances.
Okay, so is that one of those?
Yes,
Zoning?
yes,
Okay. Are you familiar with, and I believe you previously testified, are you familiar with the Emily Bear home at 111 Simpson Lane?
yes.
And when did you first observe that structure?
I don't remember the exact date. I've got it, hold on.
Okay, take your time.
March 19th, 2025.
Okay. And at that time, did you take photographs of the structure?
I did, yes.
Okay, have those been previously submitted as evidence in our prior hearing?
3 of them has, yes.
Okay, do you wish to submit any others?
I've gave everybody some. It shows the so-called permanent foundation. It's on wood blocks. And if you notice some of the pictures, the foundation is leaning and falling over. That's holding the mobile home up. And it's on a steel chassis all the way under it, runs the whole length of it. There are 2 beams. And then there are beams that go into the ground to hold it. And then the last picture is a picture of the tongue they took off of it when they pulled it in.
Do you believe the unit was delivered on its own chassis? With
Yes.
a steel tongue towed to the facility?
Yes.
To the area? Is it in a single piece?
Yes.
Were there any separate pieces of the structure that were assembled or constructed on site?
Not that I've seen, no.
Was there a building permit posted on the premises?
Yes.
Okay, did it make a reference to a definition?
Yes, a manufactured home.
Okay, could you, I think the board's previously, could we pass that amongst?
Yes.
But at the time that you rendered your decision, you had this document available. Was that actually posted on the property site?
Correct, yes. Not on the structure itself, but it was on the garage behind it in a window.
And it referenced a manufactured home at that location?
Correct.
Now, how would you, well, this a solid, continuous foundation for the structure?
No. If you notice the blocks, there are no cement, nothing holding the blocks. They're just kind of piled up in a pile and put under the trailer.
Does the word pier, do you think that would be called a pier system?
I wouldn't call it a pier, but I'm not an engineer either.
Okay, but it's not a 360
No,
degree
no,
exterior
no.
wall or block
No.
system holding up the
No.
structure? Okay. Is 111 Simpson Lane a state authorized mobile home park?
No,
And does the zoning ordinance that you enforce make reference to state authorized parks of that nature?
yes.
When was that ordinance passed by the city of Junction?
I believe it was 1973.
Okay, and do you know when Boyle County passed its zoning?
I do not.
Has it been during most of your life that
Yes.
Boyle County has had zoning?
Yes.
Since the 1990s perhaps?
Yes.
Was there also, I believe it was Exhibit 1 of our last hearing, have you had access to, let's see what this is called, housing site permit application, it's structured housing site permit application, at our last hearing noted as Exhibit 1. Does it make reference to a B1 designation under the type of manufactured home seal?
Yes.
Now, is this on file, as I understand, with the county?
Yes.
Okay. And did you have, or do you now have access to the county file or documents?
I do, I've got it.
Okay. And I'm going to make reference to that. In fact, I might just go ahead and pass that around. Share this out.
They should have a copy. Yes.
Oh, okay. And you see, it's about an inch and a half down from the very top. B1 is checked. Would you have had, Tom? Does the Boyle County zoning make reference to the designation, in addition to the HUD, of a B1 designation in the definition of a mobile home?
I'm not sure. I'd have to read it.
You just read it to you.
Yeah, read it to me.
Is a new unit that exceeds, or meets or exceeds the HUD code and has a HUD label affixed, a seal, or is a used unit less than 20 years old that has a B1 seal? Is that a part of the ordinance of Boyle County? Under the definition of manufactured home?
Yes.
Do you see where it references the B1 seal?
Yes.
What we're reading. Referencing the B1 seal as a part of the ordinance definition for a manufactured home. Okay, does it also reference being hauled in on its own chassis under the definition of mobile home, under mobile home parenthesis C?
It does.
Okay. At the time of your making your decision, having access to your visual observations, to the ordinances passed in 1973 and perhaps in the 90s by Boyle County, and to that application with B1, did you have any other information?
No.
Okay. Did you know this individual prior to this
No.
application?
No.
Did you have any reason to be angry or picking upon her for any reason?
No.
Did you ever have any argument with her?
No.
Her name, I believe, is Ms. Bayer, irrespective of her name. If it had been Mr. Hackley, would you have issued the same document
Yes.
based upon the information that you then had available?
Yes.
believe that's all I have for you. The other attorney may have some.
Ms. Thornburg. Do you have any questions?
Oh, I'm sorry. I'm sorry, I was looking at my notes here
Go ahead.
to make sure that. Mr. Terry, in your capacity as the code enforcement officer in Junction City, you visited the premises, correct?
Yes.
And after viewing those things that you have stated that you viewed while there, what was the conclusion that you reached in your official capacity? Was this a mobile home in
Yes.
violation of
Yes.
Junction City Ordinance 152,
Yes.
correct? All right.
Correct.
And you issued the notice of violation
Yes.
therefrom? Okay. I believe that is all that I have. Thank you.
Mr. Terry, a couple questions. The allegation is she's violated section 152 of Junction City's ordinances, the mobile homes. What's the VIN number of this mobile home?
I've not been in the mobile home, I couldn't tell you.
Okay. Did you see?
There are
the
no
hood label?
trespassing signs. I've not been on the property since she put those up.
So you're not aware of one, in other words?
Haven't been in it, can't
You-
say.
Yes or no, you're unaware of it?
I have not been in the house.
You saw the HUD label for this house?
I have not been in the house.
The HUD label's affixed to the outside of the home though, right?
I have not been under the house.
So you haven't seen a HUD label either?
I haven't looked for a HUD label.
You haven't looked for a HUD label? Aren't you the
Because
code
it's a mobile
enforcement-
home.
Aren't you the code enforcement officer for the city?
I am.
Okay, and you're alleging this thing's a mobile home,
It is.
correct?
That's correct.
And under the joint ordinances, isn't it true that to be a mobile home or a manufactured home,
But-
it has to have a HUD label?
The ordinance with the most restrictions takes priority, which is junctions.
So what definition are you imposing for mobile home under the Junction City ordinance?
The 152.
Well, what does that mean? It says mobile homes aren't allowed. What is mobile home?
A mobile home, it's on a chassis, you pull it in, you unhook it, you pier it up.
The board's got, section 152 here. Show me where the word chassis is, hook up, bring it in.
It's-
Where are any of those words? in
It's
this
not,
ordinance?
it's common sense.
Okay. So we're just relying on your common sense?
Yes,
Okay.
my professional opinion, that's correct.
And you said you were not an engineer,
I am not,
and you've spent
but
no
Mr.
time-
Galloway is.
And you've spent no time working in the housing building codes, the Department of Housing Building Codes.
No. Have you?
Let me ask you this. You were present for the hearing last month.
I was.
You heard Rusty Cox say that the permit application and the permit itself was on a form document that his office provides, right?
Yes.
And he said that he had only one type of that document for mobile homes, manufactured modular homes, correct?
I wasn't listening that much to him because he messed it up to begin with.
So you can't dispute that then?
No.
Let me ask you one other thing. On this B1 designation for manufactured home,
Yes.
it says is a used unit less than 20 years old that has a B1 seal, right?
Says- You need to read it all.
HUD, okay, you already said you have no idea if it has a HUD label.
Correct. I didn't crawl under it.
And then, or is a used unit less than 20 years old that has a B1 seal. This thing's a brand-new unit, right?
I don't know that it's brand new.
You don't know that either.
No, it didn't have a for sale sign on it or nothing. I mean, a sticker that it was new.
Okay, you don't know that it has a VIN, you don't know it has a HUD label,
Nope.
you don't know if it's new or used.
I just know if it looks like a duck and walks like a duck, it's usually a duck.
Mr. Terry, if your council doesn't have questions for you, the board, I have at least one or two questions for you, if you don't mind. Could you state again what a B1 seal is?
It's a single-family residential dwelling fabricated at an off-site facility that meets all the criteria below. Is a new unit that it meets or exceeds the HUD code or has a HUD label effect or is a unit less than 20 years old that has a B1 seal?
Mr. Terry, I think I misdirected you. What is a B1 seal? When you see that, what does a B1 seal mean?
I would think it'd be a mobile home
Okay.
or a manufactured home,
And
which is same.
if I'm splitting hairs here incorrectly, does a B1 seal mean something different on new versus used homes?
I have no idea.
Okay, all right, thanks, sir.
Any other questions? I don't think. Mr. Hackley?
I believe Ms. Thornberry may be calling Mr. Gallo.
Mr. Galloway will approach the podium with me, please.
This is Luther Galloway. Mr. Galloway, can you please tell the board what your current employment is?
I work for AGE Engineering as a civil engineer and surveyor, land surveyor.
So you are licensed through the state of Kentucky?
Yes.
And how long have you held this position?
This position, 22 years.
And how long have you held your license as a civil engineer?
Almost 45 years.
And what other professions or jobs have you done in that capacity?
Uh,
Were you a city engineer?
Okay, yes. Originally, I worked for the city of Lexington in the engineering department, doing basically new development, new subdivisions, plan review, approvals, worked with planning and zoning there, with the subdivision committee and other approvals for those, for plats. Then I worked for Wesley G. Witt Associates for a couple of years in Lexington, doing primarily highway work. After that, I became city engineer and assistant city manager for 22 years. And then I've been with AGE since.
Okay, so you have significant experience in dealing with building and building codes, planning and zoning?
Yes.
Would that be correct? There's been a lot of discussion here today by counsel for Ms. Bayer, as well as we heard from a representative from the state of Kentucky's Housing Development Office. Have you had occasion to communicate with someone in that office regarding the question of the definition that that department attaches to modular homes?
Yes, I have.
And what is it, can you tell us please who it was with whom you communicated?
It was Gary Feck.
And what is Mr. Feck's position in that department?
He is the director of the Division of Enforcement for building codes.
Okay. And what did Mr. Feck tell you about modular homes?
I'm not sure what
Okay.
the question is.
Can you share with the board
Okay.
here specifically what Mr. Feck's position as the director is
Okay.
on a foundation?
In the last meeting, there was significant discussion about modular M1 related to the state building codes, okay? So Rusty Cox suggested and recommended that we contact the Building Code Division in Frankfort in order to get interpretations and their information, which I did. I did it through email, but this is part of one of the emails from Gary Feck to me. And basically, this was a discussion we had dealing with, as he indicated, the not necessarily the definition, although there is a definition for these homes in the building code, in the residential building code. Basically, what he said was that, and the question really came down to, my question was permanent, on a permanent foundation. What is their definition of a permanent foundation? And this is what he said: modular homes are required to be set on a permanent foundation, typically consisting of a continuous perimeter footing with concrete or masonry foundation wall. The use of the masonry pier is permitted with limits. Modular homes must be anchored to the foundation with approved foundation anchors in the same manner and method as a site-built home. Okay. If any of you have been around building sites when they're building a house, or pretty much any building, but primarily a house, they put in the footer, they build the foundation wall up to whatever height they want, usually concrete block, then they put a plate on that top of that wall and basically concrete the anchors that holds that plate on, and then the house and everything is attached to that plate and goes on up. That's basically the process for a stick-built home, okay? That's what he indicated. He says modular homes are required to be designed, constructed, and installed in accordance with the Kentucky Residential Code. Compliance with our KRC does not negate the need to comply with local planning and zoning regulations, as code compliance and P&Z requirements are two separate issues. This is from the director of Division of Building Code Enforcement.
Did you discuss with him, or have you had the opportunity through your profession to become familiar with the various seals, specifically a B1 seal, which is the seal that the applicant indicated was on the manufactured home for which she filed an application to locate at 111 Simpson Lane?
Okay. Let me back up and answer that this way. FHA basically, or Kentucky has gotten primacy for inspection of mobile homes. And as part of that, they passed a state statute, okay, that defines and deals with B1 seals, okay? Now, a B1 seal has to go on a bunch of stuff. A B1 seal has to go on a travel trailer, a motor home, mobile homes, manufactured homes, and so forth. All of them have to have a B1 seal in order to be legal in Kentucky. A B1 seal, basically all it says is that this house or this building or this vehicle is safe for human occupation. That's basically what it says. That's basically what the definition says in the state statute.
And so through this process, you have had occasion to see the application that the owner, Emily Bayer, filed for this particular site?
Yes.
And do you have that up here?
I do.
Okay. And so when Ms. Bayer filed this application with the building inspector, she checkmarked, excuse me.
The B1 seal.
Okay. So she selected that the home she was seeking, or the unit she was seeking to move here had a B1 seal, is that?
That's
Okay.
what this says, yes.
And what model year?
It's 2024.
And is it new or used?
It's new.
Okay. And then, under manufactured home information down here, it says what about what it will sit on?
It will sit on piers on a crawl space.
There is the option to choose that it would sit on a slab, correct?
Yes,
Or other, correct?
or other.
And neither of those were checked by the applicant?
That's correct.
Okay. And then, as you said right here, the B1 seal is that it is a unit that has passed the inspection and deemed safe for a human to live in?
Correct.
Okay. In the course of this, have you had the occasion to look at Junction City's ordinance?
Yes, I have. I went
You're
to Junction
familiar.
City Council and got a copy.
Okay, and so you are familiar with that ordinance?
Yes,
And you know that that ordinance specifically prohibits within the Junction City limits the locating of a mobile home, correct?
correct.
So this is section 152 of the ordinance,
Yes,
and below is a picture of what?
of a home at 111 Simpson Lane.
That was brought in under the application applied, or excuse me, the application that we've gone over with a checked B1 seal in
Yes.
one piece,
Yes.
set on piers.
Yes.
And did you have occasion to see what type of frame it had? Does it have its own frame?
It's set on steel rails.
Okay. Does this appear to be, or would you conclude that that is a mobile home that is specifically prohibited by the Junction City ordinance?
I object to that on the basis of foundation, on the basis of speculation, on the basis of legal conclusion, on the basis
I
of
think
he's not
we-
the code enforcement officer.
I think we have established that he has significant experience in licensing as a civil engineer who has worked in the area of residential building.
Mr. Chair, the Kentucky rules of evidence are not strictly applied here. You can sustain that objection. You can allow Mr. Galloway to speak. And, you know, it's noted for the record so that if Mr. Eaton needs to bring this up as an issue at the next step, he's made his objection.
Continue on.
Okay. Basically, I've talked to any number of people, including neighbors, in relation to this. And for the average person, this appears to be a mobile home, or at least a manufactured home. And regardless of what definition you want to pull in from state statute, the appearance of this home is a critical factor because it does affect the neighborhood.
I have a kind of statement. We are talking about, you know, all the people that has experience in this particular field, engineers, modern homes and all that. So if we got an experienced person saying it's a modular home, why are we disputing that it's a modular home?
Because we have experienced people who also say that this is a mobile home, and when you look at the applicable definitions under our joint ordinances, this fits the definition of a mobile home based on what the applicant herself placed on her application to locate this. And it is a violation of the Junction City ordinance that does not permit mobile homes. And the the Junction City ordinance is the most restrictive of all the ordinances. And under applicable law, it is the most restrictive ordinance that is to be enforced when there is a conflict between not only ordinances such as the joint ordinance and the separate city ordinance, be it Junction City, Paravel, or Danville, but also the ordinance is to control if there is a conflict with a state requirement, such as what you've heard testimony for, stating that under state building code, this has one particular definition. Under our joint ordinances, it is a thing, a dwelling that is defined and prohibited in the zone where it has been placed, both under the joint ordinances and more specifically under the Junction City ordinance.
And I will say also that the Junction City ordinance was passed in 1973. And to my knowledge, there's not been a mobile home set in the city limits since then, okay?
I thought there was one sitting on property now.
That's a double wide. Okay, the one next door, that's a double wide.
But it's a mobile home, right?
That is a mobile home.
But that
Unfortunately.
doesn't make it not a mobile home.
It doesn't, no.
But also, just if there is one there, because that is wrong and ought not be there, does not mean that the ordinances should not and cannot be enforced moving forward.
I understand that too, but what you just said, because there's one there, doesn't mean that it's not supposed to be there, or it has to, whatever, move or whatever, it's not supposed to be there, and don't allow another one to be there. Is that what you were saying?
What I'm saying is that if no one sought to enforce the locating of this one that is next door, if it was not brought to the attention of the code enforcement officer, if the code enforcement officer did not have occasion to go out and inspect that and issue a notice of violation for it, and it is there and has been for I don't know how long, 3 years, that does not mean that the code enforcement officer is not correct when he learns that there is a complaint that there has been a mobile home placed on another lot, 111 Simpson Lane. And he goes out and on his own testimony, he makes these observations that lead him to conclude that it is a mobile home and it is in violation of the city ordinance, then he is correct in issuing a notice of violation. There's nothing that prohibits him from doing that if previously one was not noticed and caught, for lack of a better.
And that's for approval of a mobile home, right? You saying that the mobile homes cannot be there, right? You said the mobile homes cannot be on this land. And just because one there now, it slipped through the cracks, you can't allow any more mobile homes to be there on that property.
This particular case in front of you, the ordinance, the code enforcement officer sought to enforce a valid ordinance against it, and he can do that. I'm not sure if I'm answering.
Yeah, you answered that. But the thing that it is that we keep saying mobile home, and this has been identified and proven to be a modular home. So I don't understand why we keep talking about mobile home.
Because it is our position that this is not a modular home.
But we have proof to saying that it is.
That sounds like you have reached the conclusion for yourself. that-
Now, I'm reading what the facts here, what he's got here, like I'm listening to his facts of him being an engineer. We have facts, and he's giving us evidence here that this is a modular home and not a mobile home.
I think where there may be some confusion, which is understandable, is that just because Kentucky Residential Building Code says that something is or is not a modular home or a manufactured home, that definition, what the state of Kentucky is putting on it for purposes of their residential building code, does not negate what Junction City in 1974 adopted as their ordinance prohibiting mobile homes. And then subsequently, Boyle County, in its joint ordinances, which came along quite a bit later, and most recently, I think were amended in 2020, it also prohibits manufactured or mobile homes in the R1A zone, which you have heard testimony that this is in the R1A zone. So our position is that you have something, a dwelling unit that has been located here in conflict with the joint ordinances, but more importantly, with the Junction City ordinances, which leads me to what my summary, what my statement to you all would be in representing my client, Mr. Galloway, if you all are ready for that, or if it's the appropriate time for it. Mr. Smith, I recognize that other attorneys may have questions for Mr. Galloway, and really, before I wrap up, I would like to ask Mr. Galloway one last question.
Certainly.
Okay. Mr. Galloway, do you have anything that you want the board to be aware of to help clarify why the definition of this by Kentucky is not controlling?
Yes, basically, you have to understand that the ordinance written in 1973, things were a lot different back then. And there was no such thing as industrial-built homes as defined by the state. That didn't even exist. You had mobile homes, and that's what they prohibited. This Junction City gets to define what that means. They don't have to go by the state definition in the building code. They can define that on their own. The mayor's here, the city council has considered this, and they determined that it is, by their definition, a mobile home. So whatever the state says it is, or even the builder says it is somewhat moot when it comes to enforcement of the city ordinance.
And Mr. Galloway, or Ms. Thornberry, does the Junction City Code of Ordinance have a separate definition for mobile home?
There is no definition.
Okay. All right, thank you.
There's no definition of any of those in the ordinance, which is typical. Most codified ordinances don't have a definition. Usually the ordinance is written as with whereases and then it be ordained, and very seldom, especially back in 73, they just didn't add definitions to the ordinance.
Does his answer there of the definition and how a legislative body of the city enacts an ordinance, that's an important difference there for this purpose? Did that?
Could I ask a question?
Yes.
I haven't.
We'll get to both of you. Who wants to go first?
Well, mine is directly related to the last question from the board, and that is, does the Boyle County joint ordinance with the city, passed by the city and the county in the 90s, does it define mobile homes and manufactured homes?
Yes.
Okay, thank you.
Mr. Reed. Mr. Hackley, could you repeat that?
I didn't hear the question.
I'm sorry.
Could you come to the microphone?
The question was asked by the board. If the 1974 ordinance by Junction City gave a specific definition of mobile homes, the answer was no. My follow-up question was, did the joint ordinance, you got two ordinances here, one passed by the county and the city in the 1990s that brought Junction into Boyle County zoning while we're here, does it define mobile and manufactured homes? And the answer was yes, and that's been one of the exhibits that you've seen previously.
Mr. Galloway, what your home on Simpson Lane is zoned in R1A, correct?
Actually, my home is in the county,
In the, you outside of
but it is zoned R1A, yes.
R1A. And
Yes.
that comes from the joint ordinances, correct?
Comes from the zoning map, yes.
But that comes from the joint ordinances.
Oh, sure,
Yes, and Junction City adopted those joint ordinances, correct?
yes, and the county did too.
And you had some discussion about this application. You don't have any reason to dispute that this home was issued an M seal from the HBC, correct?
I have no reason to dispute it. I haven't seen it, but I haven't seen your documentation, but I have no reason to dispute it, no.
Okay. And on the flip side of that, you have not seen a HUD label affixed to my client's home, correct?
Well, of course not.
Of course not.
Ms. Thornberry, you have more input?
I don't know that we are finished with the.
Hang on, Ms. Thornberry, you're finished?
I think.
Just a second, sir.
I'm sorry, So I think Mr. Galloway then would have been my only witness. Sorry, this is so different from a courtroom that it's hard to follow process. And so I believe this gentleman wants to speak, but I do want to give a summation on behalf of Mr. Galloway before this concludes. So I don't know when in the order you.
If this is just public input, then I'd like you to continue and proceed, and then we'll open the floor for public input.
Okay, thank you. Okay. So we've heard a lot here tonight about the specifics of what the Kentucky Building Code defines something as, and what various other entities define something as. And as I was preparing for this evening, one thing that stood out to me is that when, and I'm going to get real big picture here, so please bear with me, because that helps me and hopefully helps you all hone in on exactly what it is you're looking at. The administrative appeal process is one where an individual who believes that they have been wronged by the decision of an administrative official can appeal that administrative official's determination to you all via the administrative appeal application. And you all have a copy of that application. And specifically, she is appealing from the notice of violation that was issued by Junction City, and she is appealing from the stop work order that was issued by the Boyle County Building Inspector. In the administrative appeal section of the Boyle County Joint Ordinances, the required findings, or what I would call your standard of review as a board, is set forth. And you, as the board, on appeal, are to review, and it says that it shall be limited, your review shall be limited to a determination of whether or not the administrative official's decision being appealed from was based on substantial evidence, or was it arbitrary and capricious? And very importantly, that standard says that the board
shall not substitute its judgment for the judgment of the administrative official. And I will say, at our last hearing in May, when this was tabled, I too, along with, I believe, other attorneys, got caught up in defining the various things and kind of down in the weeds, like especially attorneys can do. So the important thing for you all to keep in mind is that the lens that you are reviewing this through is the lens of whether or not Scott Terry, in his official capacity as the code enforcement officer for Junction City, whether based on the information that he had at that time, which you have heard his testimony as to what that information was, what his observations were, what the building permit was that he saw, whether or not at that time that he made his decision to issue the notice of violation, was he acting? Did he issue that notice based on substantial evidence or not? It is not your duty or your role to supplant what his judgment was. Each of you sitting up there may have your own idea or judgment as to whether or not what the administrative official, Mr. Terry, concluded was a mobile home is or is not a mobile home. But under our ordinances, you are not to substitute your judgment for his. And his judgment was that based on his observations of this thing coming in on wheels, pulled by a tongue, existing on its own steel chassis, placed on piers, not a permanent foundation, and accompanied by a building permit that he observed, calling it a manufactured home, mobile home, his conclusion was this was a mobile home. And he based his conclusion on substantial observations and his own judgment. In order to understand, and this was what I was starting to discuss with you, Mr. McGuire, and this is a really hard component of our ordinances for anybody to grapple with, but the joint ordinances that are adopted by Boyle County as a whole do not negate or take away the authority of the city of Danville, the city of Perryville, or the city of Junction City by and through their respective councils to adopt their own ordinances. That is what Junction City did in 1973 prior to there even being a Boyle County joint ordinance. So when that joint ordinance was adopted by Boyle County under KRS Chapter 100, which is where the legislature delegated to the counties and other local governments the authority and the ability to enact their own ordinances and rules and regulations governing land use and land use management, the joint ordinances specifically provide that if the joint ordinance is in conflict with one of those sub-cities within the joint ordinance area, Boyle County, if there is a conflict between those two, our ordinances state that the one that is to control is the most restrictive. And then along that same vein, our ordinances provide that, and again, they provide this through the power delegated to our local government by the legislature, that if there is a conflict with state law, regulation, what have you, the more restrictive is what controls. And let me find that so that I can point you to it, because Mr. Miles, I saw your puzzle there. In section 1.7, it says conflict with existing law. It is not intended by this ordinance, being the joint ordinances, to repeal or in any way impair or interfere with any existing provision of law, ordinance, or resolution, with any rules, regulations, permits previously adopted, or which shall be adopted. It goes on to say that, however, where this ordinance imposes a greater restriction, this ordinance being the joint ordinances, where it imposes a greater restriction upon the use of buildings or premises, which is what we have in this case, premises, than are imposed or required by existing provisions of law, ordinance, or resolution, or by such rules, regulations, or permits, or by such private restrictions, the provisions of this ordinance shall control. So our joint ordinances can be stricter than the state of Kentucky's laws, and Junction City's ordinances can be stricter than our joint ordinances. And that is what we are seeing here in this particular situation. So you all have heard the testimony of the code enforcement officer, that he rendered his decision and issued the notice of violation based upon the information that he had at that time, what he observed, what he saw, and what he concluded that to be, what he judged that to be. And our ordinances specifically give our administrative officials that authority. And it's not the place of this governing body to supplant his judgment with its own judgment. So what I would encourage you all to do is to keep that big picture in mind, keep that standard of review in mind. Don't let all of the back and forth about what is the state definition of something, what is the state seal for something, don't let that smoke and mirrors detract from what your overall task is of simply determining whether or not Mr. Terry made his decision to issue that notice of violation on substantial evidence, or was it arbitrary and capricious? And I would say that we have not heard testimony here today from anyone that reaches the standard of this being an arbitrary and capricious decision. You heard testimony from Mr. Terry that he did not know, he does not know this particular property owner. He did not go out there with an intention to target her or target what she brought in. He went to look at what came. And based on what he saw, he made the determination that it was a violation of the ordinances of Junction City, which he is tasked with enforcing. And given that Junction City's ordinance is stricter than the county's ordinance, we don't need to go any further than affirming Junction City's code enforcement officer's issuance of a notice of violation. We don't need to get down into the weeds of what the Boyle County building inspector, Mr. Cox, may have done or not done. And because I know it, from a human perspective, it's hard to hear testimony that Emily Bayer has spent money and incurred a cost in purchasing this mobile home that was brought in and placed there. That should not factor into the decision that lies before you. That is a decision, or that is a determination that is the proper basis of a lawsuit for damages, because she has potentially may be able to prove specific damages. But that's not a remedy for this body. That's a remedy for the Circuit Court of Boyle County. That in and of itself does not and should not factor into your decision of whether or not Mr. Terry based his official decision on substantial evidence. So, that is what I have for you. Thank you.
Thank you much. I would like to open the floor on a limited basis to public input for or against the appeal. If your only statement is it looks like a mobile home, I think we've heard quite enough of that tonight, and I would ask you to save that comment. But if you have new information that we have not heard tonight, I would encourage you to come up either for or against. Mrs. Bayer.
My name is Morris Tyler. My wife and I own the adjoining property, as I've shown you there, with the nice brick house that I was raised in. I've been affiliated with this street for 71 years, and never have we had anything like this, and that is going to destroy the value of our properties. We have 2 of them there. Having this sitting there, and it's sitting in a swamp, the pillars that it is sitting on are already going down. It's sitting on 2 beams instead of a foundation, like modular homes are or anything. But as you've already heard, the ordinances in Junction City, there is no mobile home or modular home allowed there. Neither one of them, no matter what it is. It's not allowed. I hope you'd please, I hope that picture shows you, and I don't think any of y'all would want that put by your house, and it doesn't even have a front door facing the street. It's horrible.
Thanks, sir.
Thank you.
Ma'am.
And the people she's had there, most of those are renters. On her letter.
Excuse me. Good evening. Thank you for your time. My name is Emily Bayer. I live at the property. I have never had any renters at that property. I've been part of this community for 7 years, and I've worked hard to give back. While living there, I went back to school and became a paramedic, and today I serve the public in that role. I never set out to cause any kind of trouble. In fact, I went out of my way to make sure I was following every rule when I bought my modular home. I involved the city and the county officials. I submitted plans, and after due diligence by multiple parties, as you've heard, I received a permit. That's why I was completely blindsided when the city objected after the home was placed. At that point, the time for objections has passed. If the city had concerns, the proper time to raise them was during the permitting process, not after. The city is now demanding that I remove my house. This would be very difficult and unfeasible for me since I have a mortgage on it tying the house to the land, and the house has been placed on a permanent foundation. Once finished, this house will be the most valuable property on the street unless someone else gets reassessed higher by the PVA. In fact, my house is worth more in the PVA today than Mr. Galloway's house, which was the highest valued house on the street. And for those worried about property values, I can only say this. My house is far better than the abandoned, dangerous structure that I bought in 2018 for $18,000. It was unlivable. The floor was caving in. There was a 3-inch gap in 2 corners where you could see daylight. The ceiling had fallen in. And I discovered that the kitchen floor was built over another floor that had caved in. The kitchen floor was built on 2x4s on 2-foot centers. And it just went on from there. I had 4 different construction people tell me, tear it down, it's not worth saving, it's a money pit, get rid of it, okay? After I tore it down, yes, it's a swamp. It's been raining since January. I have a stop work order on the house. I don't think I'm even allowed to put drainage from the house to the street because that could be construed as work on the house. So yes, I have a swamp in my front yard and I hate it. I really wished that I could have saved the old house. It was kind of cute, but there was really no saving it, you know. I want to address the concerns from neighbors about how my new house looks. I understand, but I'm not finished with it. I haven't been allowed to. What you see now is not the final product. It's supposed to have a cinder block skirt around it, that it would be, you know, whatever the plans are for the house, that were submitted and approved, it's supposed to have the cinder block skirt around it that looks like a foundation, right? It's part of the foundation. I haven't been allowed to work on the house. Yes, I see my peers are starting to go. I'm not allowed to dress them. I really want to. I'm seeing that there are 2 of them. This stop work order is endangering my property. It's endangering a brand new house I bought. I purchased the most affordable modular I could. I ordered a really plain one. Yes, it looks plain. Half the front of it is no windows, okay? I have plans for that. But after I get occupancy, I have plans for that. I have plans to make it look better. Things like a pergola in front of that, landscaping, and even a window fireplace. So there's gonna be a window there and you'll be able to see my fire from the street. It'll be really cute when I'm done. I'd like to put a Japanese garden in front too, with a water feature so I can make use of the swamp out front. And maybe, you know, make use of the fact that it's lower. But if I'm not allowed to put a water feature, I'll just get a whole lot of fill dirt and grade it back towards the street. I'm just asking for a chance to complete what I started, something I began with full permission and good faith. Thank you.
Thank you, ma'am.
Do I have an opportunity to sum up our positions that we asked for?
Please make it brief.
I will make it brief. I understand we're late. Council's right that the standard of review is whether or not the code enforcement officer, Mr. Terry, had substantial evidence to support the notice of violation. But you heard, I would say, you heard evidence to show that he did not. He lacked the ability to explain whether or not it had a HUD label, whether or not it had a VIN statement or a VIN number associated with it. He relied only on his visual observations. Council said another way, he relied on what he saw. Kind of more fundamentally, I asked him to describe what mobile home even meant under the ordinance he was trying to enforce, and he was unable to do so based on just what he felt his opinion supported was his answer. There was no ability to dispute that this home was regulated, built, all the things I've said before, consistent with a modular home. No ability to dispute that this thing has an M seal. No ability to dispute that this thing is built consistent with the Kentucky Building Code. I don't present that evidence to you for the purpose of supplanting your judgment on his. I present those things to you to show you this is what evidence looks like about whether or not this home was a modular home or a manufactured home or a mobile home or HUD-regulated home. These are the types of things you would look for. HUD label, M seal, VIN number, KBC, HUD standards, approvals from HBC. Those are the things you look for. I present those things to show you substantial evidence did not support this decision to say that's a mobile home based on my visual observations and what I saw. It is arbitrary and capricious to make up rules and enforce them arbitrarily. To say this home, based on what I look like, based on what this looks like, is a mobile home, but the one next door with the HUD label does not trigger my senses that it's a mobile home. That is arbitrary and capricious. A word on this kind of idea that there's one ordinance versus the other, and that's a whole big issue you guys need to figure out. It's not. Both ordinances say no mobile homes. There's no conflict. There's no more restrictive, they're both easy to apply at the same time. No mobile homes. The Junction City ordinances expressly adopt, or Junction City has since adopted, the joint ordinances that provide definitions. So that's how you read them together. There's now a joint ordinance that says this is what a mobile home is. This is what a modular home is. This is what a manufactured home is. If you look at the Junction City ordinances where it says no mobile homes, it's not a far leap to then look to the Junction City ordinances to see what mobile home means. And as I've said time and time again, and if you take nothing away from this other than this, under your ordinances that the code enforcement is trying to enforce, in order for this home to be a mobile home, it has to have a HUD label. That's just what it requires, and it doesn't. Because there's not substantial evidence to show that it's a mobile home, that it has a HUD label, this appeal should be sustained. It's just that simple. Folks, there's reference to lawsuit and property values. Guys, it's as simple as this. It is what it is, and it isn't what it isn't. And that's the end of it. And people's opinions about it don't really matter and shouldn't be considered. Thank you.
Thank you, Mr. Eden.
Mr. Chair, may I have about half that much time?
What's that?
May I have half that much time?
No, sir, your opportunity to speak is passed already. You got closing arguments. I'm sorry. So, public hearing portion for this is closed, and it is time for us to deliberate as a board and come up with finding on whether or not to sustain or reject the appeal. So, any questions for anybody who has made statements this evening?
The other mobile home, the neighbor, the next door neighbor, how long has it been there?
2020 is what the PDA says.
2020 is when it was set.
That's when the first assessment is. I don't know when it came there, but that's when the first assessment is on the PDA.
Mr. Terry, were you the code enforcement officer at that time?
I was not.
You were not. Was there a code enforcement officer at that time? No. So we didn't have anybody to check anything. at that particular time? I'm sorry?
Can I elaborate on that?
Sure.
Okay.
If I'm the one in charge here.
Yeah, if you don't
Please.
mind coming to the microphone, if you've got a statement to make. Thanks, sir.
Because that is a mobile home.
I'm Jim Douglas, mayor in Junction City. In 2020, this could have happened and it would have been very easy. We were under COVID rules. There was a lot that just didn't go on. Most days there was nobody in the office. And that could have been the reason that a mobile home went in there in 2020 without being seen. I'm not aware of it or nobody complained about it.
Okay. Thank you for your response. Actually, kind of one follow-up question there. So did Mr. Terry, did you discover this home on your own, or was it brought to your attention by somebody else and you went out and checked it?
I got a call and went and checked it.
You got a call and went and checked it. Okay. So are you allowed to elaborate who called it in?
It came through the clerk.
Came through the clerk, no message, didn't go out and check with them or anything? Okay. I just wonder why any of the other neighbors.
Somebody on the street that
Right, I just don't understand why none of the neighbors called in about the current, the pre-existing mobile home that was there first, and it was never brought to anybody's attention.
I can tell you why. Because that home is beautiful. It's well under.
That's irrelevant.
Yeah.
It's a mobile home, and it says no mobile home or no mobile home. That is irrelevant.
If
It
you've
is
got
not a
some input-
modular home.
If you've
That
got
is a
some
mobile
input to
home.
address this,
It has a HUD tag. It comes in on a trailer in two pieces, not just one.
hey, Willie, avoid any back and forth. I know you're stating your position on it, but just avoid back and forth.
Sure.
They're not on a microphone, so what they say is not being recorded.
Okay.
Chair, I'm going to object. If I didn't get this due summation, why should you?
He's answering.
Opportunity for these people to speak and provide answers from the
Whatever the board
audience,
wants.
and not for legal argument.
Fair point.
The board is permitted to ask questions at the point.
Yeah.
That's the way that we hear from anyone else except for the board.
And
The board
if
has-
if he's answering a question for Mr. Baker, then it's allowed, and you can respond to Mr. Baker's question too.
Mr. Baker wishes to ask him the question. I don't know that he does.
Well, he asked a question in general.
If Mr. Baker would like me to, I just have a response to that, if you'd like me to. respond.
Please.
Thank you. I think you're right. It is irrelevant as to whether or not it is a mobile home or is not a modular home. I think it's relevant for the purposes of this proceeding, though, because it underscores the arbitrariness that is underlying this enforcement action to begin with. This lady just said it. It looks nice. That's why nobody complained about it. This other one, they don't like the way it looks. But to your point, it has nothing to do with how your guys' ordinances define these things. And until somebody has evidence about what this home is or is not, based on what the ordinances say, that's really all that there's left to discuss.
Thanks, sir. Mr. Ackley, if you've got, please come to the microphone.
I would suggest, Mr. Baker, that's not relevant at all with regard to arbitrary and capriciousness. If in fact, this enforcement officer, you've got to make an arbitrary and capricious judgment regarding Scott Terry, not just a position, but against Scott Terry. Scott Terry was not an administrator in the year 2020. There was a 2.5-month time period. I could not enter a courtroom in 2020. Society shut down. I ended up farming and eating at truck stops at night because it was the only restaurants that were open. That's why that other it is a mobile home. You're right, it's a double-wide mobile home. It snuck in, as did many things during the period of COVID that got done that were not reviewed appropriately by this board, by the county enforcement officer, by the junction, by the state police. That was simply a condition of the time and the era. And that is not an indication of an arbitrary and capricious lack of conduct for something he could not have done, given that he was not an employee at the time.
Thanks, sir.
I think this is a question I have for Ms. Thornberry. There's been a lot of discussion about HUD labels. I think the other way under our definitions that you can talk about manufactured and mobile is if there's a B1 seal, if it's a used unit, that has a B1 seal. And I wonder how you address the word used when this is a new model.
I'm not sure, I'm totally.
I think that if you look at the B1 seal, that's the way that this fits into our definition.
So when I looked at our definitions, I looked at these definitions and then compared them to what the applicant applied for with the building inspector, which you all have in your packet as exhibit, I think it was 5. And the applicant on her application stated that she was applying for, well, excuse me, let me flip this up that Mr. Galloway has over here so all of you can see. Thank you. Yes. It was a home seal of a B1, and it was a new unit. And so when you look at our definitions, a B1 seal is a used unit. A new unit has to exceed the HUD code. It has to be affixed to a permanent foundation, has to have the perimeter skirting, has to have a roof constructed of a certain way, and has to have conventional residential siding. A mobile home is defined as something that is not the manufactured home, and it meets or it exceeds the HUD code, or is a used unit. This is not a used unit. Is that what you're asking?
That is what I'm asking. I think that you can be a manufactured home or a mobile home if you have a HUD seal, or if you're both a used unit and you have a B1 seal. And where this is a new one, I'm wondering what definition it is that you're asking the board to apply.
So under, as I articulated up here, what I'm asking the board to do is to apply the standard of review that is under section 3.64, I believe it is, that I read, where they are not to substitute their own judgment for the judgment of the administrative official, being the Junction City Code Enforcement Officer, Scott Terry, who went out, looked at this as best that he could at that time, and saw a building permit for a manufactured home, which is not permissible in that zone. And because, as we heard him testify, because this unit has a steel frame entirely of its own, sits on its own chassis, was moved in as one solid unit, nothing put together, no on-site construction. It rolled in there on wheels with a tongue on its own solid frame. That is what his official judgment was. And so when it comes to findings, I'm asking that this board do what it is tasked to do, which is simply to determine whether the official judgment was based on substantial evidence, and I believe the testimony has shown that it is. Does that answer your?
It does.
I have a factual answer to your question.
I think I do want to hear it, but I just want to confirm that where we're talking about definitions here, you're asking for us to look at Junction City Ordinance, which says no mobile homes, and then, for context of a mobile home, refer to Mr. Terry and his professional judgment.
Yes.
As opposed to looking at what's,
Because I believe that the ordinances say, and Mr. Terry's notice of violation in his testimony here today indicates that the junction ordinance is more restrictive than the joint.
okay.
So that is the more restrictive one would apply. And most importantly, the board's judgment is not to be imparted in place of his. It's to look through that lens that I described of what he
think you're going to find the board is very receptive to the standard of review. They're not looking to supplant the judgment. I just want to make sure we have the definitions. To that end, Eric, what's a B1 seal?
Yeah,
How does
just
that?
real quick, here's what happened on that. The application is a form application that Rusty Cox had. He has no separate modular application. So it says at the top, manufactured, and the options were to click B1, B2, or HUD. It's true that under the manufactured definition, a used B1 house can be a manufactured house if other things are met, including having a HUD label. There's no option here for M seal. So what happened is when this got filled out, B1 got clicked along with new, and B1 just means seal issued that satisfactorily passed and deemed safe for human occupancy. If an M seal is issued, it's mutually exclusive from a B1 seal or a HUD seal, the same way. So ultimately what happened is an M seal was issued. So there is no B1 situation happening here. The problem is frankly, Boyle County Building Inspection Office needs more accurate applications that accommodate a modular home and select M seal right here where that goes.
Mr. Graham, can I ask you what you're going to testify to?
The B1 seal.
Satisfied with Mr. Eaton.
Okay.
It sounds like there's not one on this.
A B1 seal would only be issued for occupancy. That says when it's set up, the manufactured housing inspector will issue a B1 seal that says it is safe to occupy.
Okay, thank you.
Used.
Right.
Any other questions from the board? Would anybody want to make a motion one way or the other?
Mr. Smith, I got to be sure I understand which way, whether I'm yin or yang here. We have an appeal.
Yes, sir.
If we affirm the appeal, what does that mean?
It is to overrule the stop work order, the cease and desist, the violation, any of those orders that were cited in the appeal, the things that are preventing Ms. Bear from completing installation of her home.
Mr. Chairman, I make a motion, we affirm the appeal.
Professor Miles, are you amenable to incorporating the tendered findings that you received from applicant counsel in support? I've reviewed them. I thought they.
Yes, please.
Okay.
Steve, explain it one more time.
Okay, so Professor Miles' motion was to affirm the appeal, which is ruling in favor of Mr. Eaton and his client. He's doing that based on the appellant's proposed findings of facts, which you have 23 paragraphs that kind of outline Mr. Eaton's argument tonight. And I would suggest adding to those 23 that there is a manufactured home next door as shown by the HUD label on that adjoining manufactured home.
And there's an M seal. That needs to be added as a finding as well. There is an M seal issue for that.
I don't know, Henry, that two wrongs make a right, so I don't know that you saying that there's a mobile home next door is relevant.
That's not relevant.
Yeah.
I'm hearing that your motion does not incorporate the fact that there is a manufactured home next door. That's not being added to this.
No, that's not part of my
Mr. Eaton-
thinking.
Mr. Eaton also asked to add that there is an M seal on Ms. Bear's home. Is that something you'd like to add to these?
Oh, I forgot what an M means. What? Oh, that it is modular.
Exhibit 6.
Yes, yes.
Mr. Chair, I'll second his motion.
I think Lonnie is already. Is that- Yeah, he thirds it, okay. Then second by Jim. Any further discussion? So voting yes would affirm the appeal and allow Mrs. Bear to continue with her home. Voting no would be contrary to that. Any questions? All in favor? All opposed? 4-3 pass. You were good to go, Mrs. Bear.
Thank you for your consideration.
Thank you for everybody's time this evening. We are still not done with our meeting, but anybody here for that is welcome to stick around. Please, I'm sorry, but don't.
If it looks like a duck argument, doesn't. Well, we got.
I don't care if she doesn't do anything to it. There's a house across from me. I don't like to come up into the house, but I can't go over and tell them.
All right, we need to continue on with our meeting. If everybody could please keep it down.
Thank you, guys. Thank you.
Thank you, Mr. Eaton. Appreciate your time. Any other old business tonight?
Mr. Chair, it's been brought to my attention that Mr. Leskiv is here.
Who?
That Mr. Leskiv is here, the applicant for the short-term rental. I would suggest, and my apologies to Mr. Leskiv, that we continue with hearing this matter at the next meeting. We voted to table it earlier, and if, someone were to have gone home and they would have otherwise deposed it, that could be a way that they could overturn your permit if we were to grant it tonight. So I think it's procedurally safest if we wait till next month and hear your application then.
Yeah, I would think that our table would stand. You weren't here when we made the motion to table, and I think that next month is appropriate. New business tonight, chair and vice chair appointments. Man, it might be a tough night for that one.
Make a motion that Steve stays where he's at.
I can make an argument for it.
And I suggest that Mr. Napier stay where he's at.
All right, we've got a motion by Lonnie, second by whoever. Anybody? Anybody?
We're at 9.
Pick one.
Can I assume that Mr. Sutherland is agreeable to be reappointed?
3 more years.
Regardless of tonight's outcome, do find this board enjoyable. I don't know why, but yeah, I'll stick around. And I appreciate everybody here this evening who was grounded out and listened to lengthy arguments. But yes, be glad to continue on as chair, but only if Lonnie continues on as the vice chair.
I accept. I'm learning a lot, so yeah.
So do we have a motion to reappoint the current slate of officers? I think so. Okay. All right.
So, yeah, that was by Lonnie, second by Mike. Any further discussion? You sure? All in favor? All opposed?
How was your first time? How was your first time?
It was so good. I'm so out of it. I have not had my third and fourth cup of coffee yet, but it was good, honestly. For the record, not
Yeah.
bad. Honestly, that's as good as it can get. So yeah, can't complain.
Any other new business this evening?
No, Mr. Chair.
Would look for a motion to adjourn.
So sorry.
Amen.
Hallelujah.
Anywhere there.
Motion by Jim, seconded by everybody. All in favor, please get up and leave.